Thanks, everybody, for wanting to hear what we have to say. I really appreciate it. And I just want to take a brief minute to thank my dear friend, Dr. Pat Hines, who amazes me every year how she puts together this beautiful event. Not only is the program so rich with content that's important and so interesting to all of us, but I don't know if she special orders the weather, but it's always spectacular. And you know, and the food and the entertainment is just wonderful. So I look forward to chatting with all of you over the next day or so. And again, I thank you so much for your attention to our panel. I'm delighted to introduce my friends and colleagues, Audrey Powers from Blue Origin, Caryn Schenewerk, who, like, I have to say this, Caryn just arrived from El Paso. Weather was not her friend, and not the airline's friend. So Caryn, thank you so much for driving, you know, like a crazy person to get here on time. And Kelly Garehime from ULA. So we're all lawyers, but we're all nice. We're not going to sue anybody, I swear to you. And we're just going to have a conversation about law and policy and what it really means to be a commercial space company. And the reason I wanted to have this conversation is because I have been in this industry for quite a long time. I think I've had the great pleasure of knowing many of you. I've been practicing in this field for over 25 years. And as many of you know, my practice focuses on all things regulatory and transactional in the space industry. And when I started, I would get the most interesting questions about what it means to be a lawyer in the commercial space industry. And it took me a while to figure out that some people thought it meant commercial real estate, which was, you know, it's very amusing. But I'd have to explain, no, not that kind of commercial space. I'm not, you know, doing like, you know, leasing car dealership space or, you know, office space. It's actually space in space. But I forgot to major in physics, so the only way to get into this industry that I'm so passionate about was going to law school, so it worked out. Then I would get, oh, well, it must mean advertising in space. I mean, maybe, as you know, you might know, the National Space Council's User Advisory Group, at the recommendation of Administrator Bridenstine, is actually setting up a working group to explore the issue of advertising in space, sponsorship on launch vehicles, astronauts doing promotional work. And that's all a very interesting topic that I think NASA's explored in the past, and NASA with now industry and the Space Council will be exploring it in the future. But I can assure you that's also not what I do. I don't sell billboards in space. And yet my practice is in fact focusing on commercial space. So I thought, what better way to tackle this issue and discuss it with all of you than to have three lawyers who also practice in this field, work for, you know, major participants in this exciting industry. And we're going to talk about procurement issues, customers, who are the customers, what are the regulatory issues, policy issues, what kind of feedback they get on the question of what is commercial space, what is it like to be a lawyer in that industry. So I'm going to take a seat and facilitate the conversation with some questions. Of course, we'll have time for questions from the audience. And then I'm also going to ask, I'm going to start off by asking each one of the speakers to talk a little bit about themselves, what they do at their companies, and let's just start off with the broad question of what does it mean to you to be a lawyer in a commercial space company? So with that, you know, Audrey, can I start with you? Can you
Sure.
Introduce yourself and tackle that question? Right.
Sure.
And then we'll do Caryn and Kelly and then back to me.
Okay. Well, thanks very much, first of all, for everyone's attention and for that great introduction. I very much enjoy coming to this conference. I'm very appreciative that I was invited to speak on this panel. So I'm the Deputy General Counsel at Blue Origin, and my role spans many, many things, but probably the things that I work most on are regulatory and legislative affairs. So all of our FAA licensing needs, a lot of the efforts that the speakers have been talking about this morning with the space policy directives that have arrived recently are kind of changing the nature of how the industry is regulated. So I support a lot of those issues. I also negotiate a lot of commercial contracts with our efforts to build a launch site manufacturing complex in Florida. A lot of our engine test activities and procurement activities that go on for our engine programs. So it's kind of varied. Certainly complex supplier relationships. I handle a lot of those negotiations. HR, labor and employment issue, anything else that kind of comes up too. So that's the scope of my role.
Well, it is an honor and a pleasure to be here. This is my first time attending ISPCS, so it was certainly very motivated to get here this morning after being canceled yesterday due to weather, not space activities in the NAS. And in fact, it's funny, Franceska, your comment about commercial space. Just last week, I was in Nashville, Tennessee, where I had the honor to be on a panel about commercial space at an Airports Council International conference. And apologies, I literally ran in here. And so we realized about halfway through our, the discussion about commercial space and our introductions that half the people there believed they were coming to a discussion of commercial space in airports. Yeah. And it was kind of a sad thing to see some people get up and leave, and and what was great though is I saw some people go out and bring people back in because they're like, they're talking about space. It's really cool. so yeah, not that boring commercial space stuff. So like Audrey, in the course of working at SpaceX, I have had the honor of working on things like real estate, but I actually spend most of my time thinking about the things that we do that are truly space law, and I have the honor of talking about that as an adjunct professor at Georgetown Law Center as well. And that really focuses on these questions of how are we regulated by the FAA, how do we work with NOAA and remote sensing, what does it look like to launch Spectrum with the FCC. It's a whole host of really interesting questions about how we actually are a very regulated industry in the course of our core business, on top of course, all the other things that we have to do because we are manufacturers, we are operators, and we are employers. So it's a wonderful time, I think, to be in the industry, and it is certainly an honor to be here, to be on this panel with my distinguished colleagues talking about this topic.
And I am Kelly Garehime. I'm from ULA, Associate General Counsel, and my background is in government contracts, which may not be a surprise to some of you working at ULA, but I am responsible for our FAA licensing, just recently got an operator's license, and I support our commercial sales team and supply chain through government and commercial transactions. So excited to be here. Thanks for having me.
So Kelly, that's actually a great segue into one of the topics I wanted to cover on this panel, and that is the role of procurement, how things are procured and what is procured, and how that, in my opinion, helps define what it means to be a commercial space company as opposed to a traditional government contractor to NASA. And since you have had both roles, you've worn both hats, you wear both hats, let me pose this question to you. So do you think that being a commercial space company that sells services as opposed to hardware, and where you enter into contracts that are maybe not traditional government contracts, but commercial terms and services, commercial terms and conditions for services as opposed to hardware. I think that's a very clear distinction between traditional government contracting and commercial services sales. But can you pick up on that?
Sure. So we sell commercial launch services to our government customers and to our commercial customers. The contracts look a little bit differently. We have a commercial Blue Book contract that we start with for commercial sales that obviously don't contain FAR and NASA flow downs. And our government sales are they're not commercial items, but they are commercial in nature. So they have, they obviously have the flow downs. But we do not sell hardware to the government. We don't sell hardware to our commercial customers. We only provide launch services.
Yeah, and I really think that is an interesting distinction because sometimes, and I've seen with new entrants to the industry, a question that I get is, well, don't I have to put this FAR clause in the contract because this is a space activity? It seems like a FAR clause is appropriate. Well, no, not if you're selling commercial launch services. And it really doesn't even matter who your customer is. And Caryn, I'm going to ask you to follow on to this because SpaceX is a CRS contractor to NASA. And even though NASA's your customer, can you talk about how that contract looks as opposed to a traditional government contract?
Sure. So one of the things that I think is an interesting part of this question about what it is to do work with the government and do work as a commercial entity that's outside, is this use of the term commercial crew and commercial cargo and the commercial programs that NASA engages in. And this discussion about why are these programs called commercial? Because these are government programs, right? So there should be a distinction. It's either commercial or it's government. But the reason the commercial term is used with regard to our commercial cargo program or the commercial crew program is because it's the manner in which the government is doing business with the government contractor. And that is in a firm fixed price manner, like it's commercial off the shelf. So that is indeed a way of procuring items by the government, is a commercial off the shelf, a COTS program, and that was what was the driver for the commercial orbital transportation systems, COTS, right? So it's really a use of a term because it's more of a commercial-like contract, which means that all the requirements are set up front, and then you have a milestone-based firm fixed-price contract, and so you get paid as you progress through those milestones. And that is distinct and importantly distinct from a cost-plus style contract, which is very much a government way of doing business and not a way in which we do business in the commercial sector. So when we are selling commercial launch services to a commercial purchaser of launch, to the majority of our customers at SpaceX, that is under a launch services agreement. Now, there may be some things that you see in both of those contracts. For example, we launch under the commercial crew program once we get into the PCMs, the post-certification missions, and under the CRS program with an FAA license. So that means that the requirements for procurement for having an FAA license, the flow downs that are related to the cross waivers, the insurance, there are some similarities that then occur because the NASA has pulled this FAA licensing requirement into the CRS and the commercial crew program. But otherwise, they're pretty distinct, and that goes to the volume and the volume of FAR clauses that you have in one versus you could have a launch services agreement that is 1, 2, 3 pages.
Yep. So, and Audrey, so Blue Origin is providing sort of different experiences, launch and a personal experience with New Shepard. But you still view all of that. You view everything Blue Origin is doing as being a commercial proposition, and you're offering commercial experiences, commercial services to your customers. Mm-hmm. Can you explain that? Explain how New Shepard and New Glenn are both commercial enterprises.
Right. So this has been pretty important as I've kind of addressed my responsibilities at Blue. With New Shepard, we have a vehicle that's being launched from a private launch site. And that means different things from a regulatory perspective, but we also have very much realized from the first flight of New Shepard, which we did under an experimental permit, we were very vocal about the fact that it was a test program. We had potential customers coming to us from day one. They just wanted access to space, right? And so this is a theme that we really took to heart at Blue Origin. They didn't care if we were running a test program. They didn't care that we had various test objectives. If we could give them 5 minutes of microgravity, they wanted it. And so what we quickly determined was we use this model of a commercial launch services contract that we engage with commercial customers. And soon NASA Flight Opportunities is very interested in what we're doing because the researchers and the universities that come through NASA Flight Opportunities said, hey, we've got New Shepard out there, NASA, can you help us get involved in that? And so then we have to look at entering into a relationship with NASA to cover our offerings on New Shepard and through the NASA Flight Opportunities program. So that is kind of a more specific example of where we've been able to use some aspects of the commercial agreement that was already our foundation to start this relationship with NASA. But there certainly were times when NASA has a very structured process for engaging operators in this way that we had to kind of work through and figure out what model are we going to use. So we certainly have not ended up in a situation where the contracts that we use to engage those types of customers are exactly the same as the commercial customers that come to us directly. And of course, this problem, when you move to something like an orbital launch vehicle like New Glenn, potentially providing commercial and government customers that is something that is much more complex for all of the reasons that Caryn and Kelly went into. So it's a much more difficult problem at that level because there are very specific structures that would be imposed on us in that situation.
But regardless of the imposition of those structures, Blue's perspective is we are providing services as a commercial entity. And
yeah, absolutely.
Yeah.
I think there are a couple of important points there. The U.S. government has a lot of very specific ideas about how they approach IP rights and data rights, and Blue Origin kind of foundationally as a company, we are developing launch vehicles from scratch, and there are some things that are very specific about the launch vehicles we're designing, particularly in the way of reusability. That's foundational to our company. And so this is when we start engaging with the government while we are still designing and developing a vehicle, things like who has rights to those designs are very, very important to a company like Blue, who started out with very commercial purposes. So those are the kinds of hurdles that exist in the traditional government system that we will need to work through. And you're absolutely right that Blue Origin is a provider of commercial services at the end of the day, and or the goods, the engines that we sell, or whatever other goods we might sell in the future.
Right.
Absolutely.
Yep, I'll get to that too. That's it. But Caryn, I want, if you don't mind, I'd like you to follow up on that because NASA is a very important customer of yours, as are commercial satellite operators who want to use the services of the Falcon. Can you talk about how you treat those customers differently, or how those customers might come to you with a different perspective, and how you have to address that? Because I'm sure your perspective is similar to Blue's in that SpaceX is a commercial company. You are selling commercial services. So how do you deal with the challenges of the sort of traditional private company customer versus the government customer?
Right, and you're spot on that we treat them the same in many respects, right? So we have vehicles that we have launched once for a commercial customer, and then they launch the second time for the NASA customer. And you're right that NASA is an incredibly important customer to SpaceX. It's part of our kind of origin story, of course, with the COTS program and the CRS program. But the ability to provide NASA the value that we provide is because we can leverage our commercial customers for the government customer, and that's true for the Air Force and our national security customers as well. So the fact that we have been able to develop a rocket that is reusable multiple times, and that rocket is the same regardless of whether it's being used for commercial customers, which, as I think I mentioned, makes up the majority of our missions on Manifest, as for a national security customer or for a civil space customer for NASA. So it's key to the kind of way that we operate that is consistent across, that we attempt to do business in the same way with the government as much as possible as we do business with our commercial customers. And that is to say that we currently only operate under firm fixed price contracts with the U.S. government, and of course with commercial customers with commercial contracts. Now, what you see happening is that with a U.S. government customer, there's a level of mission assurance and a level of contracting that is certification, perhaps, that goes well beyond what happens with a commercial customer. But there are certainly engagements with a commercial customer and benefits that cross over with both.
And Kelly, what's ULA's experience with that as well? Because traditionally you are a provider of launch services to the government customer, national security customer, civil customer, but also, you just got a contract with Viasat. Congratulations.
Sure.
And what's your perspective on this question?
Sure. So similar to what Caryn said, we generally treat the commercial customers and the government customers the same. The legal documents, the contracts will look a little bit different in that you'll have the flow downs in the government contract, likely will not have those same terms in the commercial contract. And then there's a lot more insight and oversight on the government side than there would be on the commercial side. But we believe that we have this system down, and we work with our government customers, and then the commercial customers would reap the benefits from that government oversight and insight. So if the government through that process were to identify an issue, we would make an update to our process or our system, and our commercial customers would benefit from that that engagement with the government.
So Audrey, you said, for example, one issue are IP rights. And certainly with companies that are building a launch vehicle or a space system from scratch, you want to make sure that you own your designs and you have your, you have your rights to your IP protected. And the government might, I don't want to say have a different view, but might need to understand your perspective on that, because you're not developing your launch vehicle from scratch with government funding. You're doing it on your own. So how do you explain that to the government? What's their response? Do you see an evolution with government customers into sort of understanding the needs of companies like Blue, like new entrants to the field that are doing this from scratch and are very worried about, and their investors are very worried about the protection of their IP?
Yeah, I think you make an important point, and we have seen a progression of thought in this area. I think the government relationships that we've been able to establish, they have been forward-looking, and I don't mean to suggest that these are simple engagements, because they're certainly not, but they are forward-looking, and we're trying to help them be forward-looking and explain exactly some of the concerns that you just highlighted. And we do see an understanding on their part of our concerns. And so traditional approaches to things like IP rights, they have been willing, whereas it's been very difficult to speak in generalities. So the entire design of a launch vehicle. Okay, really, what is it about the systems in the vehicle that we're creating that are crucially important to Blue Origin from a commercial perspective, from a data rights or IP perspective? And let's start really having specific conversations about what we want to protect and how, what we're willing to share and how. And the government has been open to those conversations. They have, and they're difficult conversations, but we have seen a progression of thought over the course of those relationships. Yep.
Caryn, is that your experience as well?
Yeah, so I think that this question is one of many that gives an opportunity to highlight why we are such advocates for the COTS, CRS, CCI cap to CCT cap approach of using agreements between the government and multiple people, multiple entities, to develop the requirements and develop capabilities that can potentially meet the requirements, so that under COTS, you had multiple providers who were using public-private partnerships to develop a capability that the government went then on to procure that service. And there was some co-investment, but the purpose of it was to develop a capability that the government could use, but also a commercial capability specifically, right? And so I think that you see that with this point about IP rights is one of many reasons why it works well to have the government set requirements and then allow companies to propose how you meet those requirements so as to provide the service as opposed to the specific widget designed in a specific way. Mm-hmm. And that's what we've seen happen with both the cargo and the crew program, and that these, the requirements to be a certified provider were set out, and then you work to develop a vehicle or a system that can meet those. And in doing so, one of the important pieces of that is that the provider then maintains that IP, right? And that's how you can leverage that ability, those services, so the hardware that you've developed to provide that service to the government, you can also provide it to other entities. And that's a significant difference between a cost-plus contracting mechanism and a firm fixed-price contracting mechanism. That is one of the things that is commercial, so to speak, about that approach over the COTS-plus approach.
Yeah. So, actually that's a great segue to the next topic that I'd like to cover. And that is, what are the regulatory, legal, and policy issues that go into your contracting, for example, and how is the regulatory world evolving to meet the new demands of the growing and even further emerging commercial space industry? And Eric did a great job, I thought, explaining, and Kelvin as well, sort of the prescriptive regulatory approach to the performance-based approach. And Caryn, that's very similar to what you just described, where to be truly commercial and to allow your customers to benefit from commercial efficiencies, one way is to say, what do you need? Don't worry about it. Don't try to do my job for me. I know how to get there. I'll perform in a way that achieves the outcome you want me to achieve. But currently, as Kelvin and Eric described, the regulations are set up in a way that are prescriptive, not performance-based. And how do you think, and Caryn, I'm going to start with you because of the segue, how do you think this shift needs to happen, this shift from prescriptive to performance-based?
Yeah, so I think this is a very, very important point that is thankfully picked up significant steam in the discussion around regulatory reform. It's a drumbeat that we've been kind of working at for a while, and one that I had the honor of being in a discussion before a congressional panel with these fine ladies a couple of months ago on, among other topics. And it's one that is a key issue in a growing and evolving commercial space industry where, as Eric highlighted, and as I'm sure Kelvin did as well, we have a diversity of vehicles, a diversity of kinds of operations, a diversity of places from which we are conducting those operations, and we have a great deal of innovation and expansion happening. And so in order to be able to accommodate that in a way that is efficient but also achieves the level of safety that we all need to be achieving, we've been advocating for a performance-based approach. So you maintain the level of safety that is currently required by the regulations. We think it's appropriate. And then you allow the operators, the license applicants to propose their means of compliance. And a system safety approach is one way to do that. If your approach is to follow, for example, you operate on an Air Force range and you're comfortable with what's called 91.710, and you want to put forward something that complies with that currently that is accepted by the FAA. That could still be a means of compliance. But if you also want to take an approach that is what's discussed as a system safety approach, then that could also be an approach. And that system safety approach is one of the best ways, I think, or easiest ways to describe it is that it's an alternative to a prescriptive approach that says you must do this in this way in order to achieve a regulatory approval. And we think that actually allows for innovation that will achieve higher levels of safety than an approach that dictates exactly how you do things when you do them in a specific way.
So, Audrey, I know this is a very important issue to Blue Origin as well, and we heard again this morning from Kelvin and Eric that the notice of proposed rulemaking that is going to sort of set the stage for a very, I expect, enthusiastic discussion of how to reform the FAA's launch licensing regime, at least three parts of it. Audrey, what are you expecting on February 1? And how is, in big picture, how is Blue going to approach the NPRM?
Right. Well, there was, as Eric mentioned, there was a great deal of effort put forth by the members of the Aviation Rulemaking Committee earlier this year to try to come up with consensus recommendations, and we were all involved in those discussions, and many, many other companies, large and small, as well as other areas of the government. So the federal ranges were there, and NASA was there. One thing that we're hoping is that when a rulemaking comes out in February, that it reflects some of the recommendations made by the ARC, and I think that is what we're most hopeful for. Not only because many of us have been dealing with these issues and addressing some of these problems with the FAA for a very long time, but also because even in that very discrete period of time with the ARC, we worked really, really hard to figure out, okay, we've got all these different vehicles and architectures represented in this ARC group. What works for everyone, and what are possible approaches that could work for this? So we really do hope that this voluminous report that we submitted with some follow-ups too, that those themes are represented. And the other thing, personally, that Blue Origin is very interested in seeing. Caryn was explaining the distinction between prescriptive and performance-based regulations. That both models exist in the FAA regulatory world right now. So FAA has expendable launch vehicle regulations, very much modeled after this 91.710 offering from the federal ranges. So the ranges and FAA are rather aligned when it comes to regulating expendable launch vehicle activities. So Blue Origin, as I mentioned earlier, foundational to our company is reusability, right? So we show up with New Shepard at a private launch site. We license our activities through the reusable launch vehicle regulations offered by the FAA. That structure is very much a performance-based approach. It's a system safety approach. Looks very, very different than the expendable launch vehicle regulations that FAA has traditionally imposed on expendable vehicle operators. So that worked out well when we were just at our own launch site, only dealing with the FAA for licensing of New Shepard purposes. Now we move to a federal range, and we have the Air Force imposing these traditional prescriptive requirements of 91710 and the RCC documents that many of us are familiar with. And we show up there being familiar with FAA's system safety approach to reusable launch vehicles. Those two worlds do not line up. If you put them right next to each other, they don't. There's no guidance in the industry as to how you answer both authorities with one application package. There has not been a lot of attention paid to how these two things exist together: FAA regulation and Air Force authority on federal ranges for reusable vehicles. So Blue Origin walked square into this problem when we got to the range a couple years ago and started talking about how are we going to license New Glenn. So one of the very important parts of Space Policy Directive 2 is, while the Department of Transportation is out there, trying to draft all of these new fantastic performance-based rules, it also said, very importantly, DoD, NASA, and the Department of Transportation, you have to coordinate and you have to make sure that existing regulations or requirements that might exist in those other worlds do not conflict with the efforts of the Department of Transportation to put these new rules in effect. So something that Blue Origin personally, because of our difficulty at the federal range dealing with these two authorities that have requirements that look very, very different, one thing that we're very much hoping to see in this rulemaking that comes out at the beginning of next year is that the ranges have been involved in this effort. Because if you fix the FAA regulations and make them performance-based, but you leave the Air Force requirements the same as they are today, you have not fixed the problem. You still have people answering to two authorities with regulations that look very, very different from each other whenever you're launching from a federal range. So something that the ARC put a great amount of effort into was getting consensus from operators like all of us as to what the recommendation should be for how you regulate vehicles from federal ranges that need both an FAA license and an Air Force authorization. So we're really hoping that this NPRM addresses that topic straight on and says, this is what we do about the DoD world in addition to the DOT world. Yeah.
Thank you. So Kelly, your ULA is more traditionally an ELV operator from a federal range, but I know you've been very involved in these ARC activities as well. Share with us ULA's perspective on this reform effort, and if you could touch on the range issue that Audrey raised, which my own personal opinion, I think that's going to be an enormous issue for the rulemaking. I said I've been here a while. I worked on the range safety rulemaking back in, I think, 2006, and it was enthusiastic then as well. So, but ULA's perspective, please.
Sure. So ULA absolutely supports common sense regulatory reform that's fair for everybody. We worked through a lot of these issues through the ARC, and I would say ULA's main focus was the issue that Audrey talked about, is not having the duplicative requirements from various agencies, from NASA, from Air Force, and from the FAA. So the coordination and having one single focal point, that would be the ULA's objective to see, or hope that we see in the notice of proposed rulemaking. We also like the move to a performance-based requirements, and we're optimistic about those things.
So I missed Kelvin's speech earlier, and I've certainly heard him, speak about these things before. I think that one of the things that would be something that it would be great to see is an opportunity to see some of the movement in this regard before we get to February. And we have the ComStack meeting coming up, which is the Federal Advisory Committee for the FAA's Office of Commercial Space Transportation. And I think that we would we would all benefit, the community would benefit from a discussion and hopefully some kind of update. So unless I missed it earlier today, in which case it's, you know, I'll bring that up with my aviation friends that they kept me on the ground in DC. But but if not, I would say that I mean we're all talking about these ideas, and so far we're hearing that this is having positive traction. But one of the things that I think we all would be very interested in seeing is some kind of, you know, earlier than later update on the direction that that's going, because, you know, there is a lot to be accomplished between now and February. And I know our friends at AST have been working really hard. But we certainly are all very eager to have some, you know, an opportunity to have some input and some insight into what's happening there too.
Well, that's a great point, and maybe at the ComStack, there can be some kind of a preview. I'm not aware of anything like that that's scheduled, but maybe if Kelvin is still here, we can ask him.
We are asking.
Okay, good, all right, exciting. So the fun's gonna begin before February, awesome. So Caryn, can I ask you to pick up on and then Audrey, I wanna get back to you on this as well. I wanna talk about the range issue, but I wanna broaden the question a little bit and say, as a commercial space transportation company, you fly from a variety of locations. You fly from federal ranges, you've got your own site, you fly from, I could be wrong about this, do you fly from a commercial spaceport?
So yes, because perhaps it would be a surprise for some, our operations from Kennedy Space Center are considered to be a commercial spaceport.
Mm-hmm. Is that Space
commercial
Florida,
launch.
or is it?
No, it's
okay.
not because it's Space Florida, it's because it's not officially on the Air Force Station. So we have a launch site that's at Launch Complex 40, which is on CCAFS, Cape Canaveral Air Force Station. And then we have a launch site 39A, which is not that far away, on Kennedy Space Center. Okay. And the range has authority at the Air Force Station, and the FAA has authority at 39A on Kennedy Space Center. So to the extent that we are operating from KSC under a contract for NASA or for the Air Force or some government entity, and it is not an FAA licensed launch, then then the range steps in, and the range has authority over that launch. To the extent that it is an FAA licensed launch, though, we can contract with the range for range services, which we do, but we do not have to. It is considered to be a non-federal range when you're across the fence line there. And then we have plans to develop a wholly commercial site, which means that it would not be located on federal government property, and that site is in South Texas. Mm-hmm. Yeah, but otherwise, when we operate from Vandenberg, that's on an Air Force base, so that's considered a federal range, right? We have the 30th and the 45th. Right.
So I mean, that's pretty commercial. When you're choosing from where to fly your rocket, you've managed different contractual mechanisms for addressing each of those sites. I mean, that's, I think, really, a phenomenal development for this industry, where you've got the flexibility to fly where it suits your purposes as a technical matter, where you need to serve your customers, where you need to serve your own needs. And you've got sort of receptive providers of these facilities and services, and you manage it as any commercial customer would, commercial contractor would, through contractual mechanisms that work. Right. For that system. So, and Audrey, I want, if you don't mind, would you follow up on that? Because you guys, you've got an exclusive use site, and you've...
Sure.
Yeah.
And now we're moving into Cape Canaveral with New Glenn, and this is it. I've had the question posed to me quite often. Knowing what you know now about what's going on at Cape Canaveral, would you have chosen to go there again with New Glenn? If you had the decision to make all over again, and this harkens to, you've got experience as a private site operator at West Texas for New Shepard, would you still go to the range? And I think it goes to a lot of the points that you're talking about. So at the Air Force ranges, there is an amazing amount of knowledge resident in the Air Force office at the 30th and the 45th. And we absolutely look forward to leveraging all of that knowledge from a flight safety standpoint, from a ground safety standpoint. So I don't think, but Blue Origin's approach to operating, we knew that some of these regulatory challenges would be present if we went to a range to operate New Glenn. And when we weighed all of the pros and cons, the needing to progress the legal construct surrounding this industry and the regulatory construct more specifically, that was not a reason for us to stay away. Blue Origin is a company that says we want to progress all of these things because it increases efficiency in the industry for everyone. And so we're going to go fix that system. We're going to go progress that to be more accommodating of our needs. So while we knew it would be a challenge, we didn't see it as a detriment that would keep us away from leveraging the other positives to going there.
That's great, thank you.
So you are not going over. Let me just make that perfectly clear. You're not
Wade's
going
creeping
over.
up on this
But
time.
we have, but it is time for questions from the floor, and we have got some very significant questions. And I must say, I'm really impressed with this panel. It's making a difficult topic, A, understandable, and B, very interesting, I think. The first question from the audience here, the one that most people are interested in hearing an answer to, and Franceska, I'll let you define out who should answer this. Sure. What are the biggest legal questions moving beyond LEO and GEO on toward the moon and Mars? Biggest legal questions.
Well, I will try and answer, and then I'd love my colleagues to answer as well. I think it's one of, believe it or not, one of risk management. How you write the risk management, the risk allocation provisions in your contract, because going to the moon, while some incredibly brave pioneers did it and made it look so easy in the past, we all know it's not as easy as it looks. And the other issue is, because space is inherently international, we're going to have to make sure that if it's a US company that's going to the moon and beyond, make sure that we've complied with all of the international obligations. And since the international treaties don't impose what's called a private right of action on individual parties, on private companies, for example, the obligation to make sure that the international legal requirements flow down to companies comes from the government having jurisdiction over those companies, so the US government in this case. So what will the US laws look like? How will the US government choose to regulate its domestic companies, its private citizens, when they go to the moon and Mars and beyond? Caryn, you're nodding. I'm going to pick you next.
Yeah, so I think that this is the fun stuff that we talk about in my law class, and that I hope some of my students are writing papers about right now. So it is, as Franceska perfectly articulated, we have our domestic law and then we have international law. And we have things like contracts that are key to our engagement with our customer and how we deal with risk mitigation in that regard. We have some constructs in those contracts that are required, as previously referenced, with regard to FAA's licensing, right? So informed consent, the agreements to waive claims against each other, directions of jurisdiction for claims that fall. We also have state law that comes into play. So we have informed consents at state as an acceptance of risk in some state laws that apply to human spaceflight, whether you're suborbital or you're headed off to Pluto. And so there's some interesting activity there with regard to risk mitigation and liability questions. And then we have the issues that come with our government. And then it becomes a very important question of discussions around export control, right? How you engage with your customers, what you can engage with them in doing, where you're going to do that from, who's going to do it with you. And then to what degree, how is our government deciphering the language of the Outer Space Treaty, of the Liability Convention? How has that been deciphered into statute already and into regulations? How is it in practice currently? And how is it up for discussion in the political arena, such as our government has decided to do, which is to facilitate our industry in a way that tries to promote these activities, which I think is we are really grateful for.
And Audrey, you guys have great
Yeah,
visions.
I mean, I think your points are spot on. When you look at the U.S.'s international obligations, some of these are now creeping into the Space Policy Directive, right? Who is taking care of the continuing supervision obligation that the U.S. has under the Outer Space Treaty, and then things like property rights. And so those things are starting to creep into direction from the administration and from Congress to figure these things out. Yep.
So, and Kelly, I think it might have been before you joined ULA, but you guys did go to Pluto. I mean, you flew Pluto New Horizons. And, did that create new legal challenges for you? I don't mean to put you on the spot, but how is ULA dealing with, what happens when we go and do non-traditional missions?
Yeah, I don't know specifically. I'd have to look into that, but I don't have any background on that
I think there
one.
was, because it was going to Pluto, there was a nuclear power source on board the spacecraft, because it's cold at Pluto and it's a long way. So how are you going to get there? Nuclear power source, great idea. But that created all sorts of interesting risk management issues that had to be thought about before the Atlas, was ignited.
And that raises a really, I think, important point about the exciting developments that we're seeing in the United States and international as well, but I'm proud of what we're doing here at home. And that is the difference between, or the movement into commercial activities beyond. And it's not just the government that's doing it, right? NASA has some really exciting missions planned, but so do commercial companies. And I think that is the distinguishing factor between what we're seeing happening here at home is the discussion is being driven because we have such a growing, I mean, look at this, I'm seeing in front of me a list of all these exciting companies that are doing exciting things in space that I'm sorry you're not seeing. But it goes to the point that we are driving this discussion here in the United States in ways that other places aren't.
So let me follow up on that. We've got another very interesting question. And Kelly, I'm going to put it to you first. The question is, ULA has put forward an offer to buy hydrogen and oxygen and space, presumably in situ resource utilization off moon, asteroids, you name it. Did the ULA consider chain of ownership, and are they going to pay taxes on that?
I didn't know the answer to the Pluto question. I don't know.
Okay.
I think that's got to be privileged or something.
Okay.
She can't answer that.
Well, then for the other folks up here, are Blue and SpaceX considering making a similar offer to buy off-planet resources?
So I'll say that my knowledge of tax law is very much about my own taxes. Yeah, very much terrestrial based.
Okay, if it can be taxed, the United States Congress probably will find a way. So, okay, Blue Origin, Audrey, how do you foresee NASA allowing human-tended commercial New Shepard flights through the NASA Flight Opportunities Program?
Right, so this is where we'll really face a lot of the points that Franceska raised earlier. We first and foremost are building our vehicles based on mission assurance and safety principles that govern all of our activities within Blue, whether it's an engine program or a launch services program. And we know that NASA is very interested in the opportunities to fly astronauts and payloads in this tended payload situation. So we have not yet started, but absolutely have identified to each other, NASA and Blue, that we're going to need to deal with what do NASA's certification requirements look like when you apply them to a suborbital vehicle program, a flight that lasts 15 minutes, something, a rather different scope than orbital launch activities that we've seen in the past. So that is an issue that we're very eager to work with NASA because we know they have interest, and we certainly have interest in providing those services. So that's the big question is how we get through the details of that.
Anybody else want to weigh in on how to fly NASA government employees on their vehicles? Okay, not going for it.
Well, other than saying that we're very excited to be doing it soon.
Sure.
Very, very excited.
Sure you are. Okay, let's see. This is a little bit of a complicated question, so I hope I get this one right. What are the implications of intellectual property used on your space vehicles and the FAR unencumbered clauses if your company has not vetted your engineering for potential violations of technology intellectual property? How do you make sure in the commercial speed of development that your engineers are not violating other companies' IP rights? That's a mouthful.
Well, I'll give it a shot.
Okay.
I think that's like two questions. One is like a non-disclosure question. And so you have to make sure that your engineers understand that things are proprietary and can't be disclosed. And if they are, they're in big trouble. They're fired or otherwise in trouble. And the company could be in trouble. The other question is what happens if your IP is infringed, if somebody infringes on your intellectual property. And in commercial contracts, there are believe it or not, cross waivers of liability with respect to intellectual property infringement. And those that aren't waived, and even those that are waived that are otherwise contested, turn into significant IP litigation. There's no dearth of IP litigation, which of course you want to try to avoid through comprehensively and clearly drafted contracts provisions. But I'll go back to the confidentiality issue. Just keep things quiet and don't infringe. But
yeah, I think the first thing that came to mind when you were reading it was training. So
yeah.
we have we need to look from a program-specific basis. What is the launch services offering and for what payload? So from a customer perspective, it's certainly what training do our employees need to understand where the lines are drawn with respect to what they share and how it's marked. That's one we all love, I'm sure. So that's something that we find very important is are our engineers sufficiently educated? Because I was an engineer, and I know when you get a bunch of engineers in the room, you all sit down and want to share and talk about cool stuff. And so I think really making sure your employees understand where the lines are drawn. And from a development, we have a lot of cooperative development opportunities that we talk about on New Glenn. When we're really trying to progress the industry in areas of manufacturing and design and materials. And there are a lot of folks out there with great knowledge. And so how do we share, how do we form those relationships properly with the right contractual structure in place? And then does everybody understand how they're supposed to be behaving once you put that structure in place?
And we spend a lot of time in that area.
Mm-hmm. I concur.
Very good. Okay, Kelvin was up here. Kelvin Coleman was up here a little bit earlier talking about FAA's efforts to reform licensing and simplify those methods. What recommendations would you give the FAA on things they need to simplify or reform in the regulatory world?
I'll go first to say that I'll reiterate our advocacy for performance-based regulations. I think that the other piece of that, though, is that we need to support the Office of Commercial Space Transportation in being able, in its effort to train its employees and have a employee base that can do the flight safety analysis work, that can work with us, work with the different operators who are doing things differently. Because it certainly is a shift, or will be a shift if we are all successful in this endeavor to move to a more streamlined system that can accommodate various launch sites and various kinds of operations. And that is a big shift from having a list of things that you check off, and it's prescriptive. So you do this, then you do that, then you do that, and we just check. And as long as we check this list, then you're good to go. There's a big shift to be made in the way that you staff a review, a system safety review, and you understand what level of detail you're going to need to go into, knowing when to stop. When it's acceptable that someone has proposed that these are our systems for assuring the level of safety, and these are the boundaries on that system, as opposed to needing to go to every single level of detail. So we think that is one of there is the reform that needs to happen in the regulations to the process and the review and the substance of that review, and then there is also the work that needs to be done to ensure that the office has the support to have the team that can undertake a new approach.
I think we've mentioned this ARC report a few times, which has a lot of very detailed recommendations to FAA. But in addition to that, that did not just come out of nowhere after an effort of 5 weeks. As you've seen launch cadence increase, as you've seen new operators come on board with new architectures, there are examples every day that the FAA has been working with us where we're bumping up against their regulations that are decades old. So when we say to them something like, this definition has been driving us crazy for years, that needs to change. And here are some recommendations as to how you might change that. Here are issues that we see with how that might happen. These are conversations that all of us, I think, have been having with them for a long time. So there's a lot of recommendations that have come kind of organically through just our increased operations.
I was looking out for Eric. You taking notes, Eric Stallman?
One more thing would be the timeline. So we all talked extensively about kind of various approaches. One of the suggestions from the ARC was putting together modules and having specific shorter timelines. Right now, the timeline is 180 days for the FAA to review an application. The FAA has certainly worked with us in certain instances to work on an accelerated timeline, but if we had some more certainty in the timing, I think that would give companies just some benefit to provide maybe a rapid launch or other issues surrounding timing. So that's one thing that I think that the industry and the FAA could work together to make it a little bit more streamlined, instead of having just pushing over the entire application, breaking it into pieces and working together more in real time.
We've talked about it, and I think we've all talked about it in a way of saying that it should be a file and fly. You should have your set application materials and approvals, and then you should be able to file a plan that says what launch, given this application and given this approval to undertake the operations from these various places with these various kinds of vehicles, then we say, okay, we're going to launch from Vandenberg on this day with this version of the Falcon 9.
Having worked with some of my clients in the consulting world, Air Force Space Command Manual 91710 is not your friend. I mean, it's just 7 volumes of checklists, right?
The one thing I will say about that is that what we have seen happen, and this is one of the other things that we've advocated for with regard to the FAA regulations, is that at the least, the Air Force can update its requirements with some regularity. So if any one of us goes to the Air Force and says, look, consistently you're having to give us an equivalent level of safety for this, or we're finding that this particular approach is problematic, you only call for a flight termination system that has a person in the loop, but we all want to move to this autonomous flight termination system, it's better. They can revisit that and actually run updates. And that is not a possibility with a regulation that is written and subject to the Administrative Procedures Act. So what we really need to see is a structure in the regulations and then guidance and advisory circulars that support that can be more regularly updated. Because that is one thing that the Air Force definitively has for it, is that it can evolve a little bit more quickly than regulations with the FAA.
That's a really good point.
Okay, well,
Can I just say one more thing about the FAA regulatory reform effort? So Kelvin did a great job this morning of explaining what that meant, and it addresses certain parts of the FAA regulations. 415, 431, 435, and I might be missing one or two, but those are all regarding launch licensing. I'd just like to put in a plug for Part 440, which is financial responsibility. Once we get through the NPRM that's coming out in February and we get our energy back up, I'd like to see if we can also review 14 CFR Part 440, which deals with the very comprehensive and critically important to the industry risk management regime. There's some little bits and pieces in there that sometimes keep me up at night, and I need my sleep. So.
Yes, that would definitely be an opportunity that would delay my vacation plan for after February 1.
Yeah.
Yep.
So I think we've got the yellow light up here, so we need to wrap this up. But I have one personal question I want to ask. This is a spectacular panel, and I am so impressed with the competence and the background of all our panelists. What is it about the field of space law that makes it possible for women to succeed in senior positions in this particular area that we could perhaps take to other areas?
Boy.
Because I'm looking at the panel here, and this is great. I mean,
I think one thing is I personally have had amazing mentors in my career, and one of them is sitting right here. And I think this is, I absolutely rely on these women for feedback, for debating what the right path might be. So while a lot of people see us as competitors, we are very supportive of each other in understanding some of the real difficulties that this industry is facing going forward. And I think there's kind of a natural support mechanism there that I've seen in my career as a lawyer that maybe didn't necessarily exist when I was an engineer.
Yeah, I would say that I'm lucky to have support from leaders, but I think it has to do with a willingness to be creative, to take some risks, to raise your hand and step up when somebody says, hey, does anybody know what this means? And nobody's really kind of looking at, sure, I'll take it. And part of the reason why, I've been willing to raise my hand and take it is because I've had people that I could call upon and support in the industry and among colleagues. So it's certainly, it is, I think, been helpful to look around and see other people, other women engaged in the discussion as well.
Super. Anybody else? No?
Yeah, I mean, I think that there are still more men in the industry, but I think in my experience it has been that everybody's happy to see you. So that you kind of get some opportunities and bring a different perspective than maybe some of the older aerospace folks did, and I'm happy to be here and
Super.
exciting.
Franceska, we owe you a great deal of thanks for your mentoring.
Yep.
in this
It
area.
is, it is my incredible pleasure. I'm really at a loss for words, because when I get to see people that I've mentored succeeding in the industry, whether they're male or female, I don't care. I'm a beneficiary of tremendous mentoring from the days when I was in the intelligence community, where my mentor was the first woman general counsel of NSA, first woman general counsel of CIA. She took me under her wing, and 30 years later, here I am. And when I get to be on a panel with Audrey, that's, I can't ask for anything else.
Super. Well, this has been a great panel. Let's give them a round of applause.